fabuloso. Mary Wokemus. Yeah, we can look at this after. Mary Wokemus to all the Trans Tifa soldiers. What up, Pepe Frog? What up, Brett? What up, Matt? Yo, this is a true gifter. Thank you, Matt, for all your gifts. I recognize your name. Oh, yes. I was maliciously infringing copyright. Don't you see? Take it under advisement, Matt. All right, almost ready to go, folks. Big Scotus. Big Yoshi. Wow! Thank you for the subs! Fuck yeah. Enjoy them sours. Thank you for donating, Pepe. Pepe wins. Appreciate ya. What up, Mr. Taco? Come on in. Get ready to get learned. We're gonna learn, y'all. Wow! Holy fuck! Be part of the solution. Thank you, Matt. Really appreciate you. So many gifties. You feel it, Mr. Krabs? Crazy. General settings. Alright, almost ready to go. Are you feeling it now, Mr. Pisco? Asmongold's getting pretty crazy, huh? Thank you, Matt. Wait, what's that? Guys, some incredibly big news. Some huge news. This will impact political future. And it will be news. And everyone will be talking about it. You're all here for it. You're all waiting for it. Word War Debate has announced the matchup against Pearl Davis. Anna Kasparian is stepping into the World War Debate stage for the first time at World War I, bringing years of experience as a progressive commentator, journalist, and cultural critic. Known for her sharp wit. All right, let's watch the video.
Terrible advice. She seems to have a terrible view of men, essentially chalking them up to nothing more than sex-obsessed individuals who don't care about any of the substance that any woman has and just want them to make a sandwich. I would love to live in a world where I could be a stay-at-home, housewife, but it's just not realistic. We got to pay our bills and we both have to work. But I really do think
that's like the biggest cope. We have to pay for your expensive habits. Like, that's really what it comes down to. What have we really accomplished? We don't do the majority of hard jobs in society. 1 out of 3 of us has had an abortion. 1 out of 4 of us has an STD.
All right, just kidding. All right, well, folks, thank you so much for tuning in. We have some major breaking news in the legal department from Scotus. And you guys know, if you've been watching the stream, we have been following very closely the National Guard cases. I went all the way to West Virginia, bumfuck West Virginia, to go to debate the National Guard deployments with Tim Pool and this other fucking Christian nationalist guy. We've been staying on top of the legal filings in the various different cases regarding the National Guard, the attempt by the Trump administration to get rid of, bit by bit, our democratic guardrails. And you all know this. So we give a shit about this. We care about Trump trying to institute a national police force when they're not supposed to be used that way. The National Guard are supposed to be used as part of our state militias. And only in times of pressing need and in limited circumstances are they supposed to be called into federal action. For example, when there's a fucking insurrection at the Capitol requiring the attention of our finest, our bravest soldiers. And oh, how it's been used as a cudgel against Democrats. That our respect for our processes, our institutions, the way things ought to be, has been used to show and to try to make these bad faith arguments that Democrats don't care about crime. They don't care about, murder. Ridiculous shit. When that lunatic went and killed a National Guard member, they said we had blood on our hands for criticizing the National Guard deployments. Remember that? Tim Pool said, I wanted those National Guard people to be shot and that woman to be killed. That's what they said. But putting all of that aside, though you shouldn't put it aside, you should always keep in mind the real stuff that's going on behind all these cases. These cases don't exist in a vacuum. And the bigger picture here is, little by little, Trump is trying to test the judiciary, trying to see what he can get away with, and on the flimsiest of pretexts, trying to weaponize the military for his domestic policy agenda. And so don't lose sight of that bigger picture about why we're here in the first place. As a policy matter, just to briefly recap, Trump deployed the National Guard all over the country in 5 different places. By all over, I mean a nice geographical spread. That's what I mean, not in every single state. California, Washington, in Illinois, in DC, and in Tennessee. Now, as a general rule, the Constitution gives Congress the power to set the terms by which the federal government can call forth the militia. The militia predates the Constitution. The militias don't owe their existence to the Constitution. They are not created by federal statute. They are, however, allowed to be called forth by the federal government in certain circumstances by which Congress is given the control on when and how to do that. And there were various different authorities that were being talked about under which the federal government was purporting to activate and federalize the National Guard. You get me? In the state of Illinois, in Oregon, and California, the primary authorization was the statute 10 USC 12406. It's this statute right here. And this was ostensibly in response to protests and other disruptive activities and violence, sporadic violence that occurred near ICE facilities. After ICE started doing these incredibly intrusive raids and enforcement activities that by themselves were probably legally dubious and problematic. We don't need to get into all of the racial profiling that's been going on, explicit racial profiling that one member of the Supreme Court, who also seems to be a little bit pissed off at the ruling today, was approving of. There are various different issues legally that surround the National Guard controversy. First and primarily, is this in keeping, is the federalization of the National Guard in keeping with the limits that Congress has prescribed? I mentioned at the start that Congress has the power to set forth when and how the federal government can call forth the militia. Are you complying with the law? 10 USC 12406. Separately, there's an issue of, are they enforcing civilian law in a manner that would violate posse comitatus? This is the general restriction against using the military, except in certain circumstances, as an enforcement of civilian law as a posse comitatus. It's a historical term. So that's kind of percolated in the background as well. And then broader kind of power questions. Ultimately, you should view this case and all the different surrounding litigation as a question of power. Who gets to decide? Is there a role for the courts to second guess the determinations of the President of the United States under the statute and then ultimately under the Constitution? And so this particular response by the Supreme Court says on application for stay. So putting aside the very complicated litigation that's occurring in the Ninth Circuit, this is separate. This is not to do with the deployments in LA or the deployment in Washington. This is to do with the deployment into Chicago. And there, the district court found that the federal government was not likely to succeed on their theory of 10 USC 12406. The Seventh Circuit Court of Appeals, the Intermediate Court of Appeals, Appellate Court, they sustained that lower court ruling. And then the Trump administration issued an emergency application. Thank you, Josiah. We're going through it right now. I really appreciate the support from you guys. The Trump administration requested an emergency stay of the district court order, right? They went to the Seventh Circuit and they missed, and then they went to the Supreme Court and they asked for a stay of the district court order, declaring essentially the deployment to be unlawful as a violation of 10 USC 12406. So that's why this says on application for stay, is because the government was trying to get a stay. This is not an administrative stay. This is a merit stay on the lower district court order that broadly is declaring what's going on to be, at least in some respect, illegal. So before I go any further, and don't ask questions just yet about the ruling, because guess what? I haven't read it yet. I only know a little bit. I know some of it, but I haven't read it fully. But any questions about the setup here? The question before the court has to do with proper application of 10 USC 12406. That is the specific federal statute cited as authority for the Trump administration to federalize, to call forth the state militia in Illinois. So it is in some sense, a statutory question, but it has within it embedded powers questions, embedded perhaps constitutional issues as well. Any questions before we get started on the actual? It's not a long opinion, but there are concurrences, as I understand. Everyone doing well? How can it be illegal if it's an official act by the president? Okay. I understand this is a bit of a meme question, but it's one that deserves us talking about. That Trump versus United States is not a opinion about what's illegal and what's not illegal. It's about what you can charge a former president for. So legality is not always criminality. And technically, by the direct holding of that immunity decision, it wasn't making statements as to the legality of what Trump did with the fake elector scheme, just that you couldn't charge him for it. That's me taking the question in good faith, as though it were a real question. So this is the opinion, and we'll get started unless there are other pressing concerns. Seeing none, federal immigration enforcement efforts have encountered significant resistance as well as some violence in Chicago. So this is the first sentence kind of accepting the fact pattern of the government. Question from Matt, are we going to discuss later what constitutional issues arise from the statute? Yeah, sure. Yes. According to the government, federal officers have been obstructed, threatened, and assaulted as they attempt to perform their duties. The government also alleges that an Immigration and Customs Enforcement, ICE, processing facility in Broadview, Illinois, has been the site of frequent and sometimes violent protests, damaging federal property and threatening the safety of federal officers. These attacks, the government says, have greatly impeded its efforts to enforce the immigration laws. Now, keep in mind a couple things. The first is, we've gone over the requirements of 12406-4. And just in case you guys are not familiar with it, why don't I pull them up for you? So this is the statute that the government is relying on to call forth the militia in this context. It says whenever one of these three things are present, the president can call into federal service members of the National Guard, right? So whenever one of those three exists, the president can call forth the militia. And they haven't argued the invasion prong of it, the first one. They've kind of paid lip service to number 2, rebellion or danger of rebellion, but that's not been their main argument. Their main argument has been 3. The president is unable, with the regular forces, to execute the laws of the United States. Now, in the Ninth Circuit, the big hullabaloo was over what it meant for this to be the case. Inability. What does it mean to be unable to execute the laws of the United States? But what they didn't consider in the Ninth Circuit, because perhaps no one thought about it, and what the originalist conservative judge in the district court here did find, was that regular forces could mean something more particular. So in the Ninth Circuit, they said, well, inability means significant imposition, not actual inability. We talked about why that doesn't really make much sense from the perspective of the English language. Contemporaneous dictionaries don't say unable means significant imposition. Contemporaneous dictionaries say unable means not able. This is something you learn in grade school, right? The prefix un next to able, meaning not. As in unmentionable. You can't mention them. What are some other words? You guys know the words. Unknown. You don't know them. You guys ever play Pokemons? Unknown? Well, here it says unable, not able. The Ninth Circuit panel, and they're currently still talking about it in the Ninth Circuit, and so hopefully they see reason there. They said, oh, no. When they said unable, they meant significant imposition. Bullshit. Bullshit fucking stupid. I guess text doesn't matter anymore. I guess originalism and textualism, they're just bullshit things that we don't talk about anymore. Okay? But, alright, you can have your bullshit, Ninth Circuit. Let's go to the 7th Circuit. Whatever that means, so says the 7th Circuit. Regular forces doesn't mean civilian law enforcement. That regular forces at the time that this statute and its predecessors were enacted, that this meant a specific term. That is, the troops, the professional troops, not the militia. Regular forces as opposed to the irregular forces. The regular forces are the members of the military who are professional soldiers. Members of the army, not the National Guard. And there was just a beautiful originalist analysis done by the district court, which is like, look at every one of these different instances of people referring to the regular forces. And every time it's to distinguish the troops from the militia. And so if we're reading this as originalists, as we were taught we were supposed to read it, it shouldn't be the president is significantly impeded with the regular civilian law enforcement to execute the laws of the United States. I would argue the best way is to say they are not able with the regular troops, as in not able to enforce the laws of the United States. And reading it any other way kind of renders sub 2 and sub 1 superfluous. If you read this as significant imposition, then almost by definition, any violation of 2 and 1 will be subsumed under 3. So there are additional textual reasons to read 3 the way that you most obviously should, because it would render 1 and 2 superfluous to read this as the grand exception. And not only did the Trump administration want to read sub 3 as the grand exception to calling forth the militia, they also wanted to read sub 3 as the grand exception to posse comitatus. They said sub 3, that is not just telling you when you're allowed to call forth a militia, it's also silently, implicitly allowing them to enforce civilian law whenever they want, right? So if the president is unable to, if they're significantly impeded to collect taxes, then I guess you can use the military to go collect taxes. And it's a exception to the calling forth statute, and it's an exception to posse comitatus. So goes Trump's reading. Really, you have to read the briefs to get a sense of how demonic these people are. And then they sit down for an interview with Katie Miller. And then Cam Higbee says oh wow, what a great interview. It's insane what they were arguing for. That's some background. On October 4th, 2025, the quote-unquote president called 300 members of the Illinois National Guard into active federal service to protect federal personnel and property in Illinois, particularly in and around Chicago. The following day, members of the Texas National Guard were also federalized and sent to Chicago. So we are having the irregular forces, the militias of Texas, is invading the state of Illinois. We have Texas troops under color of law, directed by a criminal president, not really president, sending state troops into Illinois, a sister state. That's what actually happened. In calling forth the guard, the president relied on 10 U.S.C. 12406 sub 3. We just looked at it, sub 3, which empowers him to federalize members of the guard if he is, quote, unable with the regular forces to execute the laws of the United States. The United States District Court for the Northern District of Illinois entered a TRO, barring the federalization and deployment of the guard in Illinois. The Seventh Circuit denied, in relevant part, the government's motion for a stay, permitting the guard to remain federalized but maintaining the bar on deployment. The government asked this court to stay the district court's order. So that's what the government is requesting. They're saying, stop the lower court from preventing our lawless behavior. After the response and reply were filed, so they filed the order, Illinois responded, right? And then the government had a reply brief. Justice Barrett referred the application to the court. So Barrett's in charge of funneling to the broader court this specific district. We directed the parties to file supplemental letter briefs on an issue the district court had not addressed, but the parties' initial brief had addressed, but the parties' initial briefs had not. The meaning of the term regular forces. In its supplemental brief, the government argued that such terms refer to civilian law enforcement officers, such as ICE officers in Federal Protective Service. respondents, that is Illinois, right? So the government says, hey, regular forces, it means whatever we want it to mean. Regular forces could mean rare pepes. That's how Trump argues. Regular forces can mean anything. And okay, but the Illinois obviously said, no, regular forces has this specific meaning. And what does the Supreme Court says? We conclude that the term regular forces likely refers to the regular forces of the United States military. Oh, shit. Oh, shit. Oh, it feels good every now and then to have some reasoned decision making. What does this mean? That means, buddy boys, if you want to use 10 U.S.C. 12406 sub 3, you don't just get to show significant imposition. So that, first of all, holding number 1, Ninth Circuit is fucking cooked, at least the panel. You totally whiffed on it. You totally fucked up. You guys are losers, the panel. You didn't think. All you did was do policy making, according to the Supreme Court. That's number 1. Because if Trump wants to take advantage of sub 3, he's going to have to show that he can't control the situation with the U.S. Army. That's what he has to show. That the situation is so cooked that he couldn't get a hold of it without using the military, all the military. And that's the Supreme Court. That's at least five justices. Can you count to 5? Because the statute requires an assessment of the military's ability to execute the laws, it likely applies only where the military could legally execute the laws. So not only is this not an exception to posse comitatus, right? It's the opposite. You understand that? So Trump was saying this sub 3 is an exception to posse comitatus. What Scotus is saying, no. Sub 3 almost certainly only applies when posse comitatus is otherwise you're allowed to use the military to enforce the law. So it's not an exception to posse comitatus. Having posse comitatus as an exception is a precondition to sub 3, which is the most plain and obvious reading of sub 3. And no one has argued that, right? No one has argued that the military is incapable of executing the laws of the United States. And in order to do that, you would need to, as a principal matter, first justify an exception to posse comitatus. Huge ruling. Oops. Such circumstances are exceptional. Under the Posse Comitatus Act, the military is prohibited from executing the laws except in cases and under circumstances expressly authorized by the Constitution or Act of Congress. So before the president can federalize the Guard under subsection sub 3, he likely must have statutory or constitutional authority to execute the laws with the regular military and must be unable with those forces to perform that function. So all of these fucking National Guard deployments have been illegal. Maybe DC. As we've said the whole time. There is no exception to posse comitatus that's applicable. You've been deploying the military in violation of law and trying to wield it and weaponize it against states and American citizens. Shame on you. And shame on all the fucking Trump supporters who tried to give cover to this criminal so-called president who's all over the Epstein files. At this preliminary stage, the government has failed to identify a source of authority that would allow the military to execute the laws in Illinois. You think? The president has not invoked a statute that provides an exception to the Posse Comitatus Act. Instead, he relies on inherent constitutional authority, according to the government, which allows him to use the military to protect federal personnel and property. But the government also claims, consistent with the long-standing view of the executive branch, that performing such protective functions does not constitute executing the law. So protecting stuff isn't executing the law. If that is correct, it is hard to see how performing those functions could constitute, quote, executing the laws under 12406 sub 3, right? So your argument defeats itself, in other words. If guarding isn't executing the law, then how are you claiming that what you're doing is executing the law by guarding? You see? This court does not lightly assume that Congress silently attaches different meanings to the same term in the same or related statutes. So what they're going to say is, no. You see, it's not executing the law for purposes of posse comitatus, but it is executing the law for purposes of 10 U.S.C. 12406. Very cool. Very nice. Thus, at least in this posture, the government has not carried its burden to show that 12406 sub 3 permits the president to federalize the Guard in the exercise of inherent authority to protect federal personnel and property in Illinois. We need not and do not address the reviewability of findings made by the president under 12406 sub 3 or any other statute. The application for stay is denied. Ooh. Love to see it. Love to see it. Unsigned order or denial. Any questions before we start the coping? Something depressing about us being this happy over tiny crumbs of common sense. Yeah, I know. It is depressing. What does unsigned mean? That no one put their name on it. And here we have Cope and Kavanaugh. Coping Kavanaugh. Let's see it. Is there any dissent? Oh, wouldn't you know? Wouldn't you know? Who would have thought? Let's see what Cope and Kavanaugh has to say. To protect federal personnel and property in Illinois, the president federalized a bunch of National Guard people. The state of Illinois sued, and as relevant here, the district court barred the president from deploying them. After the Seventh Circuit declined to stay the order, government applied for a stay. I agree with the court's decision. So he's basically saying, I would just say it with inability to with the regular forces. And it sounds like he's suggesting he shouldn't have gone on to posse comitatus. In my view, the statutory term regular forces likely refers to the U.S. military, not to federal civilian law enforcement. So everyone seems to agree with this. And that kind of is like the big, one of the major holdings here, folks. Because if a precondition to establishing the legality of calling forth the National Guard is to show the U.S. military can't enforce the law, it just doesn't seem like we're going to be anywhere close to that circumstance in any of these cases. On the current record, however, it does not appear the president has yet made the statutorily required determination that he is unable, with the U.S. military, as distinct from the federal civilian law enforcement officers, to ensure the execution of federal law. The president, of course, would have great discretion to make that determination, as the state itself acknowledges. By the way, what is Kavanaugh saying here? And this is why Kavanaugh is a dangerous hombre. What's the right way to interpret what Kavanaugh is saying right there with that sentence? Does anyone know? This is the Ryan Mullally school of bullshit. But someone come up with it, please. What is he saying with this? Someone. Bueller? What does Trump have to do for Kavanaugh to vote like a little lemming? What is all the thing that like Trump has to do? There you go. All he has to do is write a different memo. Just write a different memo. And of course, the president has complete discretion. Just write a different memo. And then of course we'll get the discretion that you so rightly require. Yeah, just claim it. Just claim it. So these are political actors if there ever was one. If there, I mean, like, think about it. He's just signaling, hey, if you just write a memo that says this on it, I'm gonna just like okay it. They love doing these little cute signals. On that narrower ground, I would deny the government's application for a stay. We need not decide more, so I would not decide more. The court goes further. The court starts by concluding that regular forces means the U.S. military. As noted, I agree with that point. So it really does seem like we have this seems like a 6-2. So it seems like we have a pretty broad majority of the court here with this point. And that's a big point. That's a big point that every single Trump justice seems to agree with. Which, my God, it's crazy that the Ninth Circuit missed that point. From there, however, the court conducts a complicated and debatable statutory analysis. The court says that under the government's argument, it is hard to see how performing those functions could constitute executing the laws under 12406 sub 3. On that premise, the court concludes that the states, at least in this posture, the government has not carried its burden to show that 12406 sub 3 permits the president to federalize the Guard in the exercise of its inherent authority to protect federal personnel and property in Illinois, even if the president finds that he is unable with the U.S. military to protect federal personnel and property from harm. The statute also separately authorizes invasion or rebellion. The court's legal interpretation, as I understand it, could lead to potentially significant implications for future crises that we cannot now foresee. Oh, these hypotheticals. Crazy, crazy. Crazy hypotheticals. Yeah, in these hypotheticals, you know what you could do? You could trivially invoke the Insurrection Act. You could trivially invoke this rebellion prong. Suppose a mob rapidly gathers outside the U.S. courthouse in Philadelphia in response to an unpopular decision or to influence the outcome of a pending matter. Suppose also the mob is threatening to storm the courthouse and attack the federal judges, prosecutors, and other personnel inside and to damage or burn down the building, thereby preventing the execution of federal law. Oh, does this sound familiar? What does this sound like? Suppose further that the U.S. military forces cannot readily mobilize to deploy to the site in time, that the local police and federal court security officers are outnumbered, and the president wants to federalize National Guard units to protect the courthaus and judges, prosecutors, and other. Under the court's order today, even in those circumstances, the president presumably could not federalize the National Guard under 12406 sub 3. And then one thing to note here is a couple points. First off, in any kind of real scenario, almost certainly the state National Guard and the governors would be on board to just send help. Okay. In any kind of real situation, as they were during January 6th. And second, to the extent that there is any sort of gap in the law, that's on Congress to rectify. Doesn't mean that, oh, just because there's bad circumstances, that must mean like we don't have to follow the law. Don't you love that, by the way? It's your job to interpret the law, Cav. It's not your job to just come up with scenarios for which the law doesn't cover. As I read it, the court's opinion does not address the president's authority under the Insurrection Act. Moreover, the court's opinion does not address or purport to disturb the president's long-asserted Article 2 authority to use the military to, as distinct from the National Guard, to protect federal personnel and property, and thereby ensure the execution of federal law. As Professor Goldsmith has succinctly explained, the protective power is the president's inherent or independent Article 2 power to protect federal personnel, property, and functions. The key point is the president can assert the protective power without reliance on Section 12406. He can deploy regular armed forces without any need to federalize the Guard. Presidents often have. One apparent ramification of the court's opinion is that it could cause the president to use the U.S. military more than the National Guard to protect federal personnel and property in the United States. Are you what are you engaged in doing here, Cav? This guy's a lightweight. This guy's a lightweight. You need to actually interpret the law. They go right to consequences, right? They go right to consequences. So yeah, this doesn't address the Insurrection Act, because guess what, buddy? Guess what, Cav? Trump did not invoke the Insurrection Act. So call us when he does invoke the Insurrection Act, and then we'll address it then. Secondly, you seem to be really just like trying to signal where you're going to lie in certain cases and showing your hand on the Trump administration. Hey, this is what you can do. Maybe write your memo a different way and maybe just use the regular armed forces more. That's clearly what he's doing here. He's just like, here are some ideas, Trump. Invoke the Insurrection Act. Idea number 2, just deploy the regular armed forces. Idea number 3, just write a separate memo that I will give discretion to. These guys are such hacks. Of course, that kind of hypothetical scenario does not often arise, and we can hope that it will not arise in the future. But the potential consequences, what are you, a lib? What are you, a socialist? Talking about consequences? Consequences, combined with the novelty and difficulty of the statutory issues addressed by the court, underscore why I would not opine more broadly than necessary to resolve this application. Why isn't it Kavanaugh who's been saying recently, like, we shouldn't be shying away from ruling on stuff that really matters? He seems like kind of schizophrenic. The court's decision reflects only likely legal conclusions and comes at a preliminary stage. That said, the decision will presumably be a form of precedent throughout the federal judiciary that requires a temporary injunction in like circumstances until this court reaches a contrary. Very similar to everything with Humphrey's executor, right? Cav, and I'm sure that's something that you care about. The court also emphasizes that the government has failed to carry its burden. In this context, the statement seems to convey the truisms that in future litigation, the court could reconsider its view of the law, or the government might seek to advance new or different arguments. Please keep doing this, and I might come a different way. Please don't hurt me. Before addressing those challenging and far-reaching statutory questions at this stage of the case, I would have at least invited further briefing and possibly also held oral argument. I am so glad, Cav, that you're saying this. Are you you're taking issue with how the case is arriving at, and like you're not having further briefing, no oral argument? Basically, your entire shadow docket precedent for the last 12 months have been dealing with very, very important situations as quickly as possible without any reasoning. Yeah, maybe that's concerning. Here, though, is not like that. As I have stated with respect to previous interim applications of substantial import and difficulty, the court can guard against mistakes or misjudgments by employing additional process when time is not available. The state's opposition to the deployment of the National Guard appears to stem in part from the state's underlying objections to the activities of federal immigration officers when making immigration stops. Who cares? The state and the government disagree about whether immigration officers have violated the Constitution in making certain immigration stops and arrests. I know, and you love the racist detention stops. The basic constitutional rules governing the dispute are long-standing and clear. The Fourth Amendment. So now he's just like, now he's trying to defend himself in like a Twitch debate. So Kavanaugh, there's been this this meme of Kavanaugh stops, right? Have you guys seen this? So Kavanaugh is taking this opportunity in a footnote to defend himself in like a Twitch panel. This is like when I defend myself of criticism on the Ethan stuff. What what Kavanaugh is doing is going to a footnote to talk about the Fourth Amendment, a right that's not at issue here at all in any respect, to defend himself against the Kavanaugh stop allegations. The Fourth Amendment requires that immigration stops must be based on reasonable suspicion of illegal presence. Stops must be brief. Arrests must be based on probable cause, and officers must not employ excessive force. Moreover, the officers must not make interior immigration stops or arrests based on race or ethnicity. And the application does not require us to delve into those disputes. Dude, these guys, their ego. Who asked you to bring this up? Kavanaugh is bringing up how he's been misinterpreted about race or ethnicity because those only pertain to stops near the border. And so he's got pissed that everyone is calling these Kavanaugh stops. And so he's taking an opportunity on a case that has nothing to do with the Fourth Amendment to just be like, hey, this case has nothing to do with the Fourth Amendment, and we're not addressing the Fourth Amendment. And also, you're not allowed to be racist. I know I kind of said that you were, but you guys misinterpreted me. You're being bad faith. Oh my god. Oh my god. Can you believe this? Like, the cojones of this guy. In sum, I vote to deny the application, but would do so on narrower grounds and would not reach the broader issues addressed by the court. Cool. Thanks, bro. And so just to get a sense of what he disagrees on, he agrees on regular forces. What he doesn't agree on is the nature of what the court says about the deployment of the military itself, where it seems like the court is implying that there is no basis to use the military domestically, unless there's an exception to posse comitatus. And the court kind of suggests that there isn't. He's like, there should be, there is. Okay. Who's ready for the true cope? The fantastic cope. Alito. Seething. Alito and Thomas seething. Can I ask a question? Yes, go. Yeah, so this could lead to action where the court orders them to stop. And then if they don't follow it, that they're held in contempt of court. But see Boasberg for how effective that has been as a deterrent. But that would be the pathway. Because no one in the DOJ is going to like charge military people with violating posse comitatus, because it's a crime technically to do that. But that would require the Department of Justice to actually charge with a crime. So how this would play out is there's an order to do something, and they don't follow it, and then they're in contempt. That's what would happen. It's how to do some real crime, homeboy. And then one day, a piano fell on my head. Consequences. Look at the U.S. Marshals. They'll write a strongly worded letter. If you don't, we'll write a letter telling you how angry we are. That's the Democrats you're at. I love Democrats. I love memes. I love Slayer. Okay. Who's ready for the real cope? And we'll take questions at the end. / if there's people who want to do call-ins. There's people who want to do call-ins, feel free. When does Alito mention the snarkers? No, I don't think he mentions those. Kinda wacky that he's not talking about those. I'm kidding. In our adversarial system of adjudication, we follow the principles of party presentation. If a party passes up what seems to us a promising argument, we do not assume the role of an advocate. Instead, we normally decide the questions that the parties chose to present. In this case, the court has unnecessarily and unwisely departed from that standard practice. Oh my God. It raised an argument that respondents waived below, and it now rules in respondents' favor on that ground. To make matters worse, the court reaches out and expresses tentative views on other highly important issues on which there is no relevant judicial precedent, and on which we have received scant briefing and no oral. Cry me a river. Can you imagine the balls? The sheer... What do the woke people say? The sheer caucasity. I don't condone. No longer a country where you can be ashamed to be white, okay? But the sheer caucasity. I'm joking. To talk about pondering on things that aren't before the court, to talk about no briefing, no oral arguments. Spare me, dude. Spare me. First, the court suggests the principal statutory provision involved in this case contains a restriction that has no grounding in the statutory text, namely that it means instead of unable with the regular force to execute the laws of the United States, it actually means unable with the regular force to execute the laws of the United States for reasons other than lack of lawful authority to do so. The court, in effect, adds new language to the text Congress enacted. This is like the laziest argument I've ever seen. So, in his mind, defining the scope of 12406 sub 3 with reference to the historical original public meaning of the terms used is adding to the statute, adding text. But when the Ninth Circuit said unable doesn't mean not able, right? Unable, that means significant imposition. Significant imposition. Huh? Even though that's not what the historical test tells us. That's not rewriting the law. And changing regular forces to mean kind of anyone, civilians, Cookie Monster, whatever we want. That's not adding new words. And look at what he's saying here. Actually means unable with the regular force to execute the laws of the United States for reasons other than the lack of lawful authority to do so. I don't even know what he's trying to get at here. Reasons other than the lack of lawful authority. What else is inability supposed to mean? Is inability here supposed to mean illegal inability? So is this supposed to be like, okay, if you're unable to execute the laws of the United States in that you're legally not allowed to? That's how we're supposed to read it? It's so lazy, and he doesn't even explain it further. Maybe he will later on. Okay. Second, the court implicitly suggests that 12406 sub 3 does not constitute an act of Congress within the meaning of that phrase in the Posse Comitatus Act. That is a surprising conclusion, to say the least. When do they say it's not an act of Congress? They just say it's not an exception to Posse Comitatus. Because it's not. Third, the court expresses the tentative view that the phrase execute the laws of the United States does not include protective functions. That even if the National Guard is properly deployed under that provision, may not be given the task of preventing potentially lethal attacks on civilian federal law enforcement officers or the takeover or destruction of government facilities. According to the court's apparent reasoning, National Guard members may enforce the immigration laws by, for example, arresting and processing aliens, but they may not perform that protective functions for which they are better suited. That too is surprising. On top of all of this, the court fails to explain why the president's inherent constitutional right to protect federal officers and property is not sufficient to justify the use of the National Guard members in the relevant areas for precisely that purpose. And I just want to add here, why the hell is that opining on stuff that wasn't waived below? Did the court or the parties proceed on that notion? Didn't Trump specifically authorize under 10 USC 12406? I'm not prepared at this point to express a definite view on these questions, but I have serious doubts about the correctness of the court's views, and I strongly disagree with the manner in which the court has disposed the application. Let's see where, if anywhere, we can. Thank you so much for the membership. Find a disagreement. Key statutory provision in this case, 10 USC 12406.3, provides in relevant part that whenever the president is unable, he may call into federal service. In the lower courts, the parties agreed that the phrase regular forces meant civilian federal law enforcement, not military service members. Respondents explicitly adopted this position in the district court. The court disagreed, but when the government challenged this holding in the Seventh Circuit, respondents declined to defend the lower court's interpretation. The Seventh Circuit did not reach the issue. The government's stay application in this court asserted that any defense of the district court's interpretation had been waived, and respondents did not dispute either that assertion or the correctness of the government's contention that regular forces were federal civilian officers. Thus, the argument that regular forces means the military was either waived or forfeited 3 times over. So, because they know that this is a loss, right? Alito knows that they're cooked on this. He has no argument on the regular forces stuff. And so the only thing he can do is point to procedure, say, procedure. That's why Trump should win, is because they didn't consider this argument. Ignoring this history, the court ordered the parties to file supplemental briefs on the meaning of regular forces. Respondents understandably rode with an argument suggested by the court and argued for the first time, and contrary to their positions below, that the regular forces means military. The majority now accepts this 11th hour argument. Never mind, the respondents had presented a contrary theory of the case in the district court. For the court, respondents' own arguments, differently directed, fell by the wayside, for they did not mesh with the court. We should decide this application based on the party-presented controversy. That controversy centered on the district court's holding that, contrary to the president's determination, civilian federal law enforcement were in fact able to execute the laws in Chicago. If the court has doubts about the party's interpretation of the phrase regular forces, it could assume the sake of argument that the party's interpretation was correct and proceed on that basis. The court has done so on many occasions. In this case, the court has no good reason to stray beyond those issues, and based on those arguments, the court should grant the application. There is no basis for rejecting the president's determination that he was unable to execute the federal immigration laws using civilian law enforcement. In concluding otherwise, the district court likely committed both legal and factual error. Okay, so are we just saying that we don't care if it's illegal or not? Interesting to me. I will begin with the district court's understanding of the applicable law. The district court held that a president is, quote, unable to execute federal law within the meaning of 10 U.S.C. 12406 only if he is literally incapable of executing the law with the regular force. That interpretation is implausible. The term regular forces means federal civilian law enforcement officers. That interpretation would mean the president could have to conclude that the immigration laws could not be enforced in Illinois, even if all other federal law enforcement activities were put on hold and every federal law enforcement officer in the country were transferred to that area and assigned to that task. Sorry, that's just the law you wrote. Why is that implausible? And here's the thing, right? Like, this is not a hermetically sealed analysis. What Alito is trying to tell you is you should ignore regular forces and just go with what everyone kind of agreed with initially before anyone actually looked at the history, right? This is what Alito's trying to do. He's saying, just look at this interpretation of regular forces where we lose and pretend it was something else, and then try to understand inability from that perspective. But you can't separate them, right? Surely inability with the regular forces, that should be read as a whole, right? You should read these words in context. And what Alito is trying to do is deceptive. He's trying to tell you, okay, I know we lose on this part of regular forces, but we should like just segment that out and pretend that it's something else. And then we should read inability in this other way, and now it looks ridiculous. Well, maybe you should read it as a cohesive whole. District court's interpretation would lead to even more outlandish results if regular forces meant the military. Is there any originalism here? Right? Where's the originalism? Where's the textual analysis? Where's the text? Where are the historical examples? Look at what Alito says. He says, ignoring the history. Oh, sorry, ignoring this history. He's talking about the procedural history. But in effect, he's ignoring the actual thing that we're supposed to do, right? We're supposed to look at the original public meaning of the text. But just like in Trump versus United States, what do they say? They talk about outcomes. They talk about consequences. This would be so bad if we read it this way. But I thought that judges were not supposed to be lawmakers. I thought judges were supposed to be judges. I thought I was told that originalism and textualism and these FedSoc people and these judges, they were the ones that we can trust to just follow the law. But do you see any of that? They're just talking about consequences. This would be so ridiculous. A less extreme interpretation of unable is much more reasonable and consistent with the way the term is commonly used. In everyday speech, a person may say that he or she is unable to perform an act simply because the adverse consequences would be unacceptable. For example, an attorney might tell a trial court judge that he or she is unable to start a trial or a particular day because the attorney is scheduled to argue a case in this court on that date and no other attorney can prepare for the argument in time. The attorney would be capable of showing up for the trial on the day in question, but the attorney's use of the term unable would be entirely natural. But what are we doing here in everyday speech? Are you looking to the original public meaning or the current public meaning of the term? And separately, if you were just want to talk about consequences, think about the consequences for this. If all we're supposed to interpret inability to mean relates to whether a consequence is unacceptable, then there's no test whatsoever. What Alito's suggesting is basically anytime the president determines that it would be bad not to use the National Guard to enforce any federal law in any circumstance, that would be enough for inability. It basically makes this sub 3 a black hole that any president could use to justify any action so long as the contrary is like unacceptable to the president. And that's what we mean by inability. As opposed to a limited exception for exceptional circumstances that is federalizing, thank you so much, the National Guard. I'm curious if your opinion here would hold if the positions were reversed, if this was a win for Trump and you disagree with the interpretation the court cited. If this was a win for Trump and I disagreed with the court, I would be against it. There are some things that I think Trump should win on in the court. And I care more about the law than I do about the political stuff. But thank you for the super chat. But do you understand, like, if all we're doing is looking at consequences, you can do this like parade of horribles on one side, but we could just offer your interpretation the other way. Do they really mean when they pass this limitation on when the president can call forth the National Guard that it was intended to swallow everything? That what we mean by inability in this context means, like, what does he say? An act would be unacceptable. The adverse consequences would be unacceptable. Any president could trivially claim that. And so Alito's not convincing in the slightest. He's not convincing on ignoring the whole doctrine that we're supposed to be following as an interpretive philosophy. He's not convincing in just ignoring the overwhelming history of regular forces, which he just like sort of glides over and says, oh, because we lose, I don't want to consider it. And he's not even convincing in the consequence analysis here. Because surely when you read it as a cohesive whole, this statute is supposed to put serious limitations on when the president can call forth the regular forces, or sorry, call forth the National Guard, right? It says you can only do so in invasion. You can only do so in rebellion or when there's a danger of rebellion, or anytime you think it would be inconvenient with respect to federal law. That's what we're supposed to read. How is that convincing? How does anybody like this dude? This dude is a hack. The district court's interpretation of unable was implausible for an additional reason. It seems to prohibit deployment of the National Guard unless the president could not execute the laws to even the slightest extent with the regular forces. The district court took what it termed a binary approach, ability or capability or not. As the Ninth Circuit has explained, moreover, a stupid panel with a preposterous ruling, Section 12406 sub 3 cannot plausibly be read to mean that so long as some amount of execution of the law remains possible, statute cannot be invoked regardless of how much execution of the law remains thwarted. It is more reasonable to interpret 12406 sub 3 to mean the president is unable when he is substantially impaired from doing so. Okay. So we're not going to do any textual analysis. None whatsoever. Does any of that look like originalism? Even 1%? No. Where are the dictionary definitions? Where is the legislative history, if you care about that kind of stuff? Where are the the other provisions of the code that were enacted at that time? Where are the debates where people would have shown that we mean this kind of lesser version of inability? Zero. These guys don't care. This is all a game for them. For Alito, this is a game. There is no standard. There's no consistent interpretive philosophy. And so, of course, he's just going to say random shit. And again, substantial impairment, that isn't the same thing as when an adverse consequence would be unacceptable. When an adverse consequence could be unacceptable does not necessarily mean substantial impairment. So there's no through line. There's no consistent doctrinal through line between the kinds of reasonability arguments that Alito is making and what he's supposed to stand for, or even the examples that he's using that he's pulling out of his big gaping rectum. The district court also erred in refusing to afford any deference to the president's determination that calling up the National Guard was needed to execute federal law. The most directly relevant Supreme Court precedent suggests that such a determination must be accepted by the courts. And so even just as a matter of powers analysis, but what Alito is saying, similar in some respects to the Ninth Circuit, is that the standard for calling forth a militia, that A, the standard should be lower instead of not able, significant impairment. Also ignore this whole thing about regular forces. So not only is he saying that the test should be lower, but he's also saying that the test should be basically just accept whatever the president says here. So a lower standard where we automatically accept whatever the president says. Why pass this statute then? Why pass it? If the test is only when the president decides significant impairment, not inability, he just gets to win no matter what, and there's no review. Why would Congress pass that statute? Where additionally it says invasion, rebellion. Oh, but anytime the president says whatever, we just have to accept it no matter what. It is so implausible. This makes no fucking sense. And then we have the Martin versus Mott example. Again, Supreme Court in Martin v. Mott goes a little beyond in terms of like, in its dicta here. But it's not holding on this court. It's not, I don't think, expressly holding on the court. It's a different statute, and the court has other precedent that has significantly rendered Martin v. Mott, in my opinion, an old, inapplicable framework. And even then, what we're talking about is not courts' determinations over whether we're at war or whatever. It's individual militia members doing so. And so there's no reading of Martin v. Mott that is necessary to resolve this case. And even if you do think it's controlling, it need not be read, I think, in the way that these crazy fascists want us to. That is Trump. Section 1 of the law governing these. Okay, we already know Martin v. Mott. We're going to skip this. The district court gave no weight to this precedent. It saw Martin as a relic, viewed its express holding as limited to the particular facts of the case, and thought it had been superseded by more recent political question decisions. Such treatment of a Supreme Court precedent that has never been overruled, narrowed, or questioned by this court was inappropriate. Fuck you, dude. You guys are talking about Humphrey's executor? Fuck you. Honestly, go to hell. I don't mean that, honestly. Figuratively. I don't like you. Even if Martin does not dictate judicial acceptance of a president's decision to call up the National Guard, both that precedent and a humble appreciation of the role of a single federal judge surely demanded that such a presidential determination be given a modicum of deference. The district court afforded none. For these reasons, the district court appears to have misunderstood what the law requires, and those legal errors alone justify a stay. Once the proper legal framework is recognized, again, nothing here about regular forces. Nothing here about regular forces whatsoever. Totally skip that. Totally skip that. And he wants to claim that he has the more plausible reading of the statute when he's ignored, a very important part of the statute, regular forces. How could you possibly render a decision about what this term inability means when you ignore what regular forces means? Surely, imagine that like this meant something crazy like Ronald McDonald. Maybe that would affect how you would read inability. A complete and total hack, and then he starts shit talking the judge, so all the MAGA people will go shit on him. When the judge, who is an originalist, who's doing your job better than you, Alito, and actually ran the historical analysis, because I don't know, maybe he's naive enough to believe that it matters. Unlike you, maybe he actually bought it. He's not a hack like you. You're just going to start talking shit, and you're citing a case that doesn't even apply. Once the proper legal framework is recognized, the president's determination must almost certainly be sustained. Jesus Christ. These bastards are in the Supreme Court. Must almost certainly be sustained. So if the president comes and says, under the new interpretation of the Supreme Court, hey, our military can't enforce the laws, Alito's going to be like, yep, I don't care how ridiculous, how preposterous, how bad faith it is, we are going to accept it. And this must almost certainly, this qualification, what does this actually mean? Does anyone know? What does must almost certainly? What does this qualification actually mean? Read between the lines. Must almost certainly be sustained. Why doesn't he say it must be sustained? Why does he say must almost certainly be? What does this mean? Why is he putting this there? Any thoughts? Give you guys a hint. Well, one, he's telling Trump to do it. I don't know. This is Batman. Conservative weasel words. You're getting close. You're getting close. What is he holding out for? Why does it need to go all the way? Not quite. There are conditions on... Yeah, you got it. Democrat. Yeah, that's what must almost certainly. Yes, congratulations. Very good, class. Now you're getting it. The government's declaration showed that ICE was really... They're being so mean to ICE. Won't someone think about ICE? Hundreds of rioters have converged at DHS facility at Broadview. They've arrived armed with shields, gas masks. They've blocked entry and exit. They've vandalized shit. The resulting violence has endangered the lives of federal personnel. Multiple rioters have been found with loaded guns, some of them semi-automatic. Rioters have hit, punched, and shoved officers, thrown bottles, rocks, tear gas canisters at officers, attempted to grab officers' firearms and munitions. This sounds familiar. Imagine being a Republican in the current era and claiming to care about this shit. Right? We can claim to care about this kind of stuff. This conduct. This is bad conduct. Bad. But imagine being a current era conservative and pretending to give a shit about any of this stuff. They found guns. They were armed. They shoved officers. They threw bottles. They had tear gas canisters. They tried to grab stuff. They tased people. They used and aimed strobe lights. They had fireworks. Imagine, yeah. That's bad, right? Imagine being a conservative and trying to give a shit about this stuff in a opinion. When the vehicle stopped, other rioters ran up and slashed the vehicle's tires. As of early October, more than 30 federal officers have suffered injuries. Multiple officers have been hospitalized. Bad, and I even think some of this meets the definitional test of insurrection. I condemn it. But what I don't think it is an excuse to just ignore the law. That's what I don't think. That's what I don't think. Are you going to comment on the progress made into the investigation of October 7th? The Collargate stuff? People think that he was telling the truth? What more is there to say? I thought we kind of all just decided that he like buzzed or shocked the dog. Is there some new development? In a widely publicized event, a federal vehicle was boxed in. 2 of the vehicles rammed into the government vehicle. These people should be charged 100%. As the agents exited their vehicle, one of the civilian vehicles was driven directly at an agent, forcing the agent to fire in self-defense. Hundreds of rioters then converged near the scene, throwing glass bottles and other dangerous objects at the agent. A federal vehicle sent to assist the besieged vehicles itself was rammed. I think that this is likely an insurrection. This kind of conduct. Under the definitional test, right? More than one person assemblage, right, together for a public purpose, frustrating the execution of at least one federal law. I'm happy to say that. Consistency pilled. Even when not on duty, federal officers have been targeted. They've been followed to their homes and doxxed. The doxing war. They've now appeared in Supreme Court opinions. Criminal enterprises have entered bounties for kidnapping or murdering immigration officers. Bad. But notice what all of this like pearl clutching is doing. Nothing. How what does it have to do with any of the legal analysis here? Local police departments have provided insufficient assistance. What, we're now allowed to commandeer local state officers? Wasn't there this whole thing about states' rights? Now the federal government's allowed to commandeer local police department. First I've heard of it. When the ramming incident was reported, internal dispatch stated, no units will respond to this. On September 13th, how does this at all affect the analysis? How does no units will respond to this? Saying we're not responding to this. This is a federal issue. Tell me, how did that affect the statutory analysis of 10 USC 12406? Are we still doing judicial opinions here? Are we still analyzing the law? In some, injuries, threats, vandalism, and harassment have significant... Oh, okay. So significant impairment means all this stuff. By the way, this would trivially be true of any police situation or enforcement pattern in the country. I'm sorry. Enforcing the law in this country contains risks like this as a matter of course. As a matter of course. Enforcing the criminal law will always necessitate these kinds of risks. And so by your standard, Alito, there is no limitation because this stuff, right, is always present. Except I don't even know what else where it wouldn't be. I guess like executing on tariff law, some financial stuff perhaps. But when it comes to apprehending people, criminal law enforcement, this is always present. And so there is no limitation. So the president can always call forth the National Guard. And that's how we should read this statute. As always letting the president do stuff. Instead of it being an exceptional circumstance where they can always call the National Guard in the federal. That makes sense. Even if the president's assessment of this situation is given no deference, these facts adequately show the federal civilian officers were unable to execute the immigration laws under what appears to be the correct understanding of that standard. Dude. This guy's a joker. He's a lolcow in a black robe. The district court disagreed but gave no good reason for doing so. Respondents, as the party seeking interim relief, bore the burden of proof. But instead of evaluating whether respondents had borne their burden, the district court brushed aside the facts set out of the government's declarations. Neither of the district court's criticisms justify the wholesale dismissal of the government's declarations. The court's first criticism concerned the failure of the two declarants to acknowledge that grand juries had declined to indict 3 of the individuals whose arrests were mentioned in the declarations. The court saw the declarants' failure to mention the grand jury's actions as evidence of mendacity, but the court did not take into account the dates on which those declarations were filed and the dates on which the grand juries declined to indict, and it did not find the declarants were aware of the grand jury's actions. Unless the declarants had such knowledge, however, there was no ground for impugning their candor. Second, the court suggested that the same declarants' descriptions of the relevant events were exaggerated because they had submitted similar declarations in another case, which a different judge found that ICE officers had likely violated protesters' First Amendment rights. Because they're just sending people who don't know shit about anything these different cases. You know, in the Kilmar case, right? We had the showing that the person was like briefed 5 minutes before he was set to testify. It's a complete shit show. But again, more would have to be known before accepting that criticism. What we do know is that the cited order in the First Amendment case did not make any credibility findings and did not discuss the government's declarations at all, much less find them false. For these reasons, the validity of the district court's two criticisms is questionable, but even if they are taken at face value, they cannot justify the court's wholesale refusal to credit the declaration's uncontested description of serious and continued violence. I think we just disagree with your test, bro. Nor can the district court's decision be justified by conclusory statements and respondents to declarations about the capability of state and local law enforcement to provide protection. Such statements provided no reason to doubt the occurrence of the incidents described in the government's declarations. And by the way, think about like how much time has passed since then to now. Do they need the National Guard right now? Where are the chaotic scenes in Chicago now? And there is an obvious difference between the capabilities of state and local police and their willingness to assist. Thus, even if we assume that a presidential determination under 12406 sub 3 is reviewable, this has now been decided, right? It is now reviewable. We've just reviewed it. Y'all just reviewed it, didn't you? What Alito is suggesting is he if he were in charge, he would have been like, sorry, we're going to motion to stay because the court was wrong to even review the decision. That's how extreme Alito is. He would have said, motion to stay granted. And, court was wrong to even hear it. I'm telling you, these guys are extreme losers, extreme weirdos, crazy people. And those facts provide more than enough support for the president's determination that he was unable to enforce the federal law. No analysis of regular forces, a sort of totally historically absent analysis of the remaining phrases of that statute. He accuses the majority of changing the language of 12406, but again, he inputted significant imposition into unable. As well as suggesting that it's like totally unreviewable for courts to even get involved in what's going on. Pretty wacky. Instead of abiding by the standard rule on party presentation, the court took it upon itself to raise the question about whether the parties understand over. Oh, okay, maybe we'll get it. Regular forces was correct. In taking the case from the court, respondents abandoned their position. The court tentatively agrees with respondents' new arguments, but even if that is correct, it does not follow that the president exceeded his lawful authority. Oh boy, I hope he's not going to say it. Regardless of how the term regular forces is defined, the president appears to have complied with it. So Alito isn't going to take a view on whether it's... Is he? I don't think he is. I think everyone acknowledges that there is no good argument against it. The provision asks where the president is unable with the regular forces, by which we mean like the military. Not only is the statement sufficient on its face, but under the presumption of regularity, the court must presume that the president properly arrived at his determination. So Alito has actually done it, right? Alito did what Kavanaugh didn't do. Alito says, we should have, even if we accepted the regular forces definition of being the regular army, we should have said, the president cannot keep these ICE protests where no one has died at bay with the military of the United States of America, with the tens of thousands of regular troops, the most advanced military in the world. Alito is saying we should have just accepted the statement of the president that he already gave, that the U.S. military by itself is not up to the task of controlling these scattered protests. That is what Alito is telling you right here. That we need to assume that the president's declaration, in which he did not claim this, constitutes sufficiency so far as the determination that Trump could not, even with the military, again, the most expensive, biggest budget, most powerful military in the history of the world, control these scattered ICE protests in which no one has died and there have been a few hospitalizations. That is how totally extreme Alito is. And Thomas, his partner in crime. He's telling you, we have to... If the president says that the military can't enforce the law, I stress again, the most powerful military, we just need to accept it. Wild. The majority does not explain why the declaration falls short. It falls short. Hey, dipshit Alito. You know why it falls short? Because obviously it falls short. Because no thinking rational person could ever say that we are just totally unable to take control of the situation in Chicago and in California with our regular troops. Instead, it breezily concludes that a president's inability to execute the law cannot be established unless the military could legally execute the laws. And this is a nuance of the majority decision, where in order to have an ascertainment that the regular forces could execute the laws, that they first need to have the legal capability to do so. In effect, the court adds new language to the statute so that it now requires that a president be unable with the regular force to execute the laws of the United States for reasons other than the lack of lawful authority to do so. We have no authority to add this new language to the text Congress enacted. I mean, just look at it, right? If it's illegal to execute the laws of the United States, how could you get into sub 3, right? It's not new text. It's like a natural consequence and of how you would read it, right? If the regular forces are unable to execute the laws of the United States in that they are legally incapable of doing so, how would they be legally allowed to be called forth for that purpose? You understand? Right? Suppose that it's illegal in the given context for the military to enforce the laws. Then how would it be legal to call forth the militias to enforce the laws that the military is not allowed to enforce? I hope that makes sense. The sole requirement set out in the text of 12406 sub 3 is that the president is unable with the regular forces to execute the laws. The text says nothing about the cause of the president's inability to execute the laws. And in ordinary usage, it is common to say that a person is unable to perform an act when the obstacle is a rule of law. Oh, ordinary usage. How about originalism, where we talk about original public meaning? For example, it would be natural to say that a person who is fully capable of operating a motor vehicle is nevertheless unable to drive to work because his or her license has been suspended. Or take one more example. It would be natural to say that a federal district court is unable to adjudicate a case in which the plaintiff sues a citizen of the same state under the state law. This use of the term unable would be entirely appropriate even if the judges, as will almost certainly be the case, is fully capable of handling such a case. By the same token, if we apply the ordinary meaning of unable to in a case involving 12406 sub 3, a president might be unable to use the military to execute the laws due to either practical or legal constraints. But why would we read it that way, right? If the president is, if there's not a situation in which the president can be legally allowed to deploy the military in any respect, why would that justify an analysis of their capability? Surely analyzing capability for purposes of calling forth the National Guard, or like this law was not just meant to give you instant and always on ability to call the National Guard. You're only supposed to federalize National Guard in exceptional circumstances. So reading it the way that Alito wants you to read it, it's like, okay, well, you're allowed to call the National Guard anytime there's a significant imposition to enforcement of any federal law, right? Any. And also if there's a legal bar to the military being operated. But it's like, huh? What this is clearly getting at is a situation in which you're deploying the military into place and the military needs help. Can we just like stop with the bullshit? We all know what this is for. What kind of situation is being envisioned? The kind of situation that's being envisioned is one in which there's like a gathering of people in a particular area, and the federal regular troops need help. And they're lawfully where they're allowed to be doing stuff. And they're like, we need help. That's what the situation is meant for. Not for situations in which the federal military can't be used at all. And that's what is being meant here. Damn, man. I mean, it just really is bad faith after bad faith. Even if we add this extra requirement, there would be reasonable grounds for concluding the president had authority to take the actions at issue. Indeed, the court seems to acknowledge as much. It notes the president invokes his inherent constitutional authority. It invokes it, doesn't say it's legal. And it cites with apparent approval a body of OLC opinion sanctioning this understanding of inherent presidential power. This is what happened here. No, it's not. The president authorized the National Guard to perform those protective activities that the Secretary of War determines are reasonably necessary to ensure the execution of federal law. Although the court recognizes this inherent presidential power, it literally does not elaborate. It's dicta. It does not explain why it is not sufficient to satisfy the new element the court has added to 12406 sub 3. So what Alito is suggesting here is that he would also vote. He's one of the at least 3 judges now that have signaled that they would vote that the president can use, not as a statutory matter, but as an inherent constitutional matter, the military troops defend any amount of federal property. And this extends to going with ICE raids, securing deportation targets. If 12406 sub 3 is triggered only when a president determines that he's unable to execute the law by using the military, it is not easy to see how a court could assess and reject such a determination. As discussed, inability should be interpreted to mean no more than serious detrimental consequences. That you've changing the language now 3 times, right? The first one was like unacceptable consequence. The second one was significant imposition. And the third one is serious detrimental consequences. Are these all the same thing? Are these synonyms? And therefore, the statutory predicate should likely be regarded as satisfied whenever the deployment of military units would have such a consequence. Assessing the impact of such a deployment would require a survey analysis of all the nation's military needs, and only a president are allowed to make such an assessment. That's what Congress wanted, right? Every time you get put into these like wormholes by Alito, just remember that this statute intended to limit the situation in which the president will do this, that Alito is interpreting this to be like maximum amount of deference, no review, and no ability whatsoever to cabin in that power. And that's how we should read this law. The court seems to suggest that posse comitatus stands in the way of what the president did here, but that is puzzling. Why is it puzzling? Why is it puzzling, actually, that posse comitatus would stand in the way of the military operating and enforcing civilian law? Isn't that exactly what posse comitatus we would expect it to do? Does the court mean to suggest that posse comitatus somehow limited a president's inherent constitutional authority? That is certainly not Congress's view. By its express terms, the posse comitatus is not a complete barrier to the use of armed forces for a range of domestic purposes, including law enforcement functions when the use of armed forces is authorized by an act of Congress, or the president determines that the use of armed forces is required to fulfill the president's obligation under the Constitution to respond promptly in times of war, insurrection, or other serious emergency. And in any event, the Posse Comitatus Act expressly permits the use of the military to execute the laws when permitted by an act of Congress, and 12406 sub 3 is, of course, part of such an act. The act states, whoever, except in cases and under circumstances expressly authorized by the Constitution or act of Congress. But that's not what this says, right? This does not authorize execution of the laws of the United States. This is a precondition towards a calling forth statute. Nowhere does this say this authorizes the president to use the military to enforce the laws. It is a precondition to calling forth the militia. It's a determination that needs to be made, not a grant of authority to use the military. So once again, yes, posse comitatus refers to acts of Congress, but it refers to acts of Congress that expressly authorize the use. And this does not authorize the use of the military to enforce civilian law. This authorizes the calling forth of militia to repel invasion, suppress the rebellion, or execute those laws. Execute those laws, that is, the militia executing such laws, when first you meet a precondition. And in this case, it wouldn't be the military. That is to say, the regular forces. It would be the National Guard. And so, no, this line is not an end run around posse comitatus. And again, reading it any other way would be insane. It would swallow all of posse comitatus. there would be no more posse comitatus left if you read it the way Alito said. All those different like express authorizations, all those express exceptions to posse comitatus, those would all go away. Because you just have the ultimate Exodia card. All 5 hidden pieces of Exodia in one. That's what Alito wants to convince you of. And just because he emphasizes act of Congress doesn't mean that 12406 sub 3 is an act of Congress that expressly authorizes the use of the Army, Navy, Marine Corps, Air Forces as a posse comitatus, or Space Force. I would not take for granted that the Posse Comitatus Act applies to federalized National Guard units. Another question this quarter. So in addition, what does Alito say? In addition to saying Posse Comitatus, this is an exception to Posse Comitatus, he also says Posse Comitatus doesn't apply to National Guard units. Or at least he says he wouldn't take it for granted. This guy is a psycho extremist. If, as the court states that the term regular forces means military, Congress clearly views the military and federalized National Guard units as distinct entities. Otherwise, 12406 would nonsensically say that the president may call up the National Guard when the National Guard is unable to execute the laws. No. Hang on a second. That doesn't follow. Okay. So what Alito is trying to suggest here is that Posse Comitatus only, it would be nonsensical to read it as limiting federalized National Guards because, of course, if federalized National Guards are part of the regular forces, then this would just be like circular. But no, this is providing the authority to activate the National Guard to be like part of the army, okay? So this is not redundant or circular in the way that he's suggesting to apply Posse Comitatus to the National Guard. This is just a precondition to treat the state militia as part of the regular forces in this limited mission, right? And so it's not weird or odd or anomalous to consider Posse Comitatus as applying to federalized National Guard members merely for our reading of 12406, because our reading of 12406 is the justification, think about this in the big picture perspective, for treating the National Guard, who are thought of as militia, in the sense of the federal army, the Marines, that kind of stuff. So there's no lack of coherence there. It makes perfect sense, right? When you bring the National Guard and you raise them to the status of regular forces, they have to follow the rules of the federal of the National Army, Navy, Marine Corps. That makes total sense. Because typically, right, the state National Guard is able to enforce the laws of the states. The militia, that's part of their job, is to enforce the laws of the states if the governor requests them to. They're allowed to do that. But when we treat them as the military, now they're subject to Posse Comitatus. And Posse Comitatus is a limitation on federal Posse Comitatus, right? It's a federal function. And so there's nothing weird about applying Posse Comitatus to federalized National Guard units, because the reading of 12406 is merely the justification for raising them to that level. I hope that makes sense. Okay, moving on. The court finds that Posse Comitatus Act relevant largely because the same phrase to execute the laws also appears in 12406. The court's reasoning appears to go as follows. Under a position long taken by the government, Posse Comitatus Act does not forbid the use of the military for protective functions. This must mean that the performance of such functions does not constitute the execution of the laws. Section 12406 sub 3 allows the use of the federalized National Guard members to execute the laws. Therefore, it follows the National Guard may not be used for protective functions. The court's reasoning rests on the presumption that a phrase has the same meaning when it's used in closely related statutory provisions. That presumption is not conclusive, and there are reasons to question its application here. So what Alito is trying to tell you is, here, execute the laws of the United States means something different than in posse comitatus. That execute the laws in posse comitatus means something different than execute the laws in the calling forth statute. Explain, Alito. OLC's interpretation of the Posse Comitatus Act is based heavily on the history and purpose of that act, not the ordinary meaning of the phrase execute the laws, which easily encompasses protective functions. Moreover, one of the OLC's reasons for narrowly interpreting the Posse Comitatus Act's reach was to avoid intrusion on the president's inherent Article 2 powers and duties. The president's constitutional duty to protect federal functioning and inherent authority to use troops if necessary to carry out this duty. Interpreting the phrase execute the laws in 12406 in accordance with the ordinary meaning of its term would not pose any similar problem. So in order to make sense of what Alito is saying, you would need to say that they're different. That in the context of posse comitatus, it's this very hyper-specified thing that ignores protection missions. But in 12406, it doesn't. On the contrary, the interpretation would be consistent with the way the phrase is used elsewhere. Under Article 2, the president must take care that the laws be faithfully executed, and the laws protecting federal officers and property are not accepted. Nor do we read the Insurrection Act, which authorizes the use of militia in the armed forces to enforce the laws, as preventing the president from ordering troops to serve protection functions. It is therefore entirely possible, by which we mean plausible, that the phrase has different meanings. We should not hastily dismiss that possibility, because interpreting 12406 in the way the court suggests would have very strange consequences that Congress is unlikely to have intended. Under the court's interpretation, National Guard members could arrest and process aliens who are subject to deportation, but they would lack statutory authorization to perform purely protective functions. Our country has traditionally been wary of using soldiers as domestic police, but it has been comfortable with their use for purely protective purposes. The court's interpretation of 12406 sub 3 assumes that Congress meant for that provision to turn this approach on its head. I honestly can't believe, actually I can't, he's a hack, that Alito would suggest the majority is turning the calling for statute on its head. In conclusion, do we have a Gorsuch? Oh, we do have a Gorsuch dissent. So this is a sneaky 5-4. All right. It's a 5-4. The court should have decided the application based on the arguments the parties chose to present, and on that basis should have granted a stay. Injecting another issue into the matter was unwise, and suggesting views on a host of important questions without adequate briefing, consideration, or prudent. Whatever one may think of what the current administration's enforcement of the immigration laws or the way ICE conducted its operation, the protection of federal officers from potentially lethal attacks should not be thwarted. I respectfully dissent. Bullshit for reasons stated. Gorsuch says that this case touches on sensitive and gravely consequential questions concerning what role the National Guard and U.S. military may play in domestic law enforcement. To be sure, as the parties observe, Congress has supplied us with some relevant statutory guidelines, but as my colleagues writing the test, the statute raises as many questions as it answers. Take just some examples. Before calling up the National Guard, must the president be unable to execute the laws merely with federal law enforcement personnel, or must he be able to do so with even just military troops? Is a presidential declaration that he is unable with the regular force to execute the laws judicially reviewable? Does 12406 sub 3 provide standalone authority permitting the president to deploy the Guard, and how does it interact with Posse Comitatus, Insurrection Act, etc.? What, if any, inherent Article 2 powers does the president have to deploy the Guard to protect all this shit? And if, as all the parties seem to assume, today's Guard is the successor to the militia, how far can this inherent presidential authority extend before it intrudes on Congress's prerogatives to decide when the militia may be used to execute the laws? If all those questions were not fraught enough, an even graver one here lurks here too. When, if ever, may the federal government deploy the professional military for domestic law enforcement purposes consistent with the Constitution? In the present posture of this case, I am not comfortable venturing an answer to any of those questions. This court has never decided a case about the meaning of 12406 sub 3, let alone explored its interaction with other statutes in this field or the Constitution. Nor do we have much help on many of these matters from the parties briefed before us, understandably given that this case comes to us in an interlocutory posture on a highly compressed schedule. Under these circumstances, caution seems to me key, and I would decide this application narrowly based only on those few arguments that the parties preserved. In their initial briefing, the parties proceeded on the premise that 12406 sub 3 statutorily permits the president to call up and deploy the National Guard when he is unable to execute federal law with civilian federal law enforcement officials. Proceeding on that same basis, I believe the declarations, he signs with Alito on the parts about the significant imposition, but he would not do anything beyond that. Okay, so there's a sneaky Let me break it down for you. I understand everything that's going on. Okay. If you're just tuning in, you're going to get all of it. The key holding here relates to the calling forth statute, this 10 U.S.C. 12406. Congress's attempt to limit the ability of the president to call forth the militia, in this case, the National Guard. 6 members of the court agree that they should decide the question of whether the term in the calling forth statute, the regular forces, refers to the military or to civilian law enforcement. They want to decide it. 3 members of the Supreme Court say we should not even touch it because the parties waived it below. That's number 1. No one seems to disagree that regular forces, the best meaning of that is the military. So even in Alito's opinion and Gorsuch, the only reason they're willing to do this little gamesmanship is because of the procedural posture of the parties. They all seem to grant, by their lack of argument to the contrary, that the best reading of regular forces is U.S. military. All right? The majority holds that because there is no specific finding as to that, and because the record does not seem to indicate that therefore the deployment's unlawful. The quibble between Kavanaugh and the majority, 5, that is Chief, Barrett, the 3 liberals, is Kavanaugh just wants them to say it's just the military, write a different memo, make a different justification, and come back to us. Okay? That's what Kavanaugh wants to do. The majority, the 5, are like, well, it says the military, you need to make those findings, but also, if you want to make those findings, you need to actually have a reason for why the military would enforce the law under the Posse Comitatus Act. We don't see that here, therefore unlawful. Kavanaugh wouldn't reach those issues. The majority and Kavanaugh all seem to agree this shit's reviewable. The shit is reviewable. And so that seems to have been decided. 5. Whether it would have deference, less clear what the deference would be and what it would look like. The court doesn't explicitly address the question of inability, meaning significant imposition or not able. But it does seem to suggest that these kinds of questions are reviewable. The question of deference does not come up that much. Alito and Clarence Thomas are on an island in terms of their wackiness. Alito seems to suggest not only should we not decide the regular forces question, we should decide the question of inability, and we should decide it in the manner that the panel in the Ninth Circuit did, meaning significant imposition. Not only that, we should decide it as a matter of like basically complete deference to the president. So the test is highly favorable to the president already in terms of we've downgraded inability to significant imposition. And also, whatever the president says on that issue is basically always binding. That's how Alito and Clarence Thomas say it. Totally predictable. Additionally, Alito and Thomas say this is an exception to Posse Comitatus. They read it like Trump does and say, not only do we give ultimate deference to the president in terms of calling forth, and we do it with respect to significant imposition, and it's very questionable whether we can review it. Also, it's very questionable whether there are any limitations on what they can do when they're actually federalized. Additionally, Alito and Thomas say, not only this, if Congress tried to limit the president, there's almost certainly some inherent presidential authority that would trump whatever Congress tried to do. So Thomas and Alito are out in the island of dictatorship, basically. It's a little cute what I'm saying, but it's not far off. Like, they are basically suggesting that the statute should be read as maximally deferential to the president. There should be very, very little, if any, opportunity for the courts to review. The limitations on enforcement by the military of civilian law are few, if any. And if Congress tried to do that, there'd be a lot of questions because of inherent constitutional authorities. Gorsuch is basically saying, we should just review this like the Ninth Circuit panel did, and in the manner that that Alito and Gorsuch did, specifically with respect to the 12406 question, and not considering the regular forces interpretive issue that appears to have been won, at least as far as all the justices are concerned. No one in this case, no justice, not a single one, seems to be willing to suggest that the district court was wrong about their originalist textual argument of regular forces. What's the upshot? The upshot is this is a massive loss for Trump. It doesn't resolve everything, but it resolves a lot. It resolves finally as a matter of, and even though the court is saying preliminarily all that stuff, you shouldn't read it that way. Very unlikely for the court to change its mind on it. The upshot is it's not a total victory on all these issues. It's a victory on a lot of big ones. On regular forces, it's a big victory. On posse comitatus, it's a big victory. The one area where there's a potential room for trickiness is if Trump tries to make the determination as to the regular forces, tries to claim an exception to posse comitatus, and then writes a new memo. Will the five stand strong? I think that based on how they wrote it, they would. That's just a prediction, but never bet on that. That's like a 60% prediction, and I give like a bunch to Trump. But the facts are much worse for Trump now. What level of deference they would apply, unclear. On the reviewability question, it seems that the court is not entertaining the jurisdictional issues full on. There might be a deference issue, but it doesn't seem like a jurisdictional bar for the court hearing the actual stuff. Another upshot. If the issue of inability versus significant imposition gets to the court, there are 3 votes already for reading it the way the Ninth Circuit panel did. Kavanaugh and then 3 uncertains. Uncertain Kavanaugh, probably leaning strongly in fit with Gorsuch and Alito and Thomas on that issue. The 2 uncertains are Barrett and the Chief on the issue of inability versus significant imposition. But the big barrier is going to be for the Trump administration to find an applicable exception to posse comitatus to continue to use sub 3. They're going to need to find one of those. And the one that's most perhaps alluring is the Insurrection Act. Any questions? Probably not on DC, right? Because the DC National Guard is under federal mobilization as a default. So the DC one is almost certainly going to be upheld. It was always a long shot because the only bar there really is either posse comitatus or the DC like home statute. And so that one is a tougher ask because it's different authorities being invoked. Now maybe there's going to be an issue of posse comitatus, but unclear. There probably need to be like a trial for that, or some kind of evidentiary hearing. But no, it's going to be a lot harder for the DC National Guard deployment to be undermined, and nothing in this case, except for some of the words regarding posse comitatus, is likely to be relevant. Because the court didn't invoke 10 U.S.C. 12406. Sorry, the administration didn't invoke 10 U.S.C. 12406 when it mobilized the DC National Guard. So a much weaker case there for plaintiffs. And they just had an adverse ruling from the DC Circuit, which is never a good sign. A good question. One quick thing on Epstein stuff. I'm seeing people going around and having this like little letter, which we don't know the authenticity of, folks. I want to stress y'all. One of the most important things that everyone needs to get in their brain all the time is, how do I know? We don't talk about Bruno ass song yet, true. How do we know this thing is what it purports to be? That's an issue of authentication. So this letter from Epstein, even if it is from Epstein, you have to be questioning like, well, he could have just did this to fuck with Trump, right? This letter. So I want you to be like a detective. Definitely call out the double standards when it comes to transparency, when it comes to like what the Republicans would have said if all this smoke existed. But you really have to be careful. Be like, isn't this weird, guys? Is this weird? I'm totally fine with that. And you guys go at it, right? And if you are doing things that are clearly memes, I'm all in favor of it. The only thing I'm just saying is like, don't go out on a limb and say things that you can't justify. Because even if this is an authentic letter, which you need to authenticate, because they might, who knows, right? They might be putting this out just to fuck with you guys. It doesn't necessarily mean it's true. And for me, the much more interesting questions are those internal DOJ comms. I don't know how many of you guys saw it, but the internal DOJ comms are like, those are more juicy. Those are juicy for me because that gets the state of mind of what the police are saying. And that to me is interesting. More so than the letter that is as of yet unauthenticated. And also its evidentiary weight should be considered in light of the fact that he killed himself, you know? So just be very careful with jumping to conclusions on particular pieces of evidence. Okay. Órale. All right. If there's no disagreements, if there's no one with any objections, if there are no more questions, I will be off. I might be back tonight, but I might go do some like last minute shopping for some people that are coming on Christmas that I didn't know about. But I might be back tonight though. I wanted to get this out to you guys. Big picture, great ruling, makes sense. The ruling makes sense. That's what's so wonderful. When we actually have rulings that make sense, that are actually, if we're gonna do originalism, let's do originalism right. Let's actually do it. And the thing that I most love is how patently unprincipled, on display, the other justices are, who are in dissent. Mainly Alito. Not an ounce of originalism in that opinion. So blatantly political. So obviously signaling how he's going to rule on different cases. Catherine on the same thing on different stuff. So clearly just like bringing up the Fourth Amendment to defend himself because he's being attacked by people of the Academy and by commenters. And it's just, it makes you almost cry a little bit, right? Like, what the fuck? Or it makes you think a little bit that you're naive, that you ever thought that this like rule of law thing, the Supreme Court was acting in good faith. Maybe that's too far, but I will say it every time those little things happen, when the court members are being so transparently conscious of the public discussion and of how they're being perceived politically, it just makes you like, what are we doing here, folks? What are we doing? Are you even doing your job? And for them to go after the district court in this case, who is doing an honest job, an originalist conservative at the district court level, doing an honest job at originalism, for him to take a whack at him, for Alito to take a whack at the district court judge, it's just so, it's moi. It shows how partisan Alito is and how much of a hack he is. By far, the least principled justice on the Supreme Court. Once a hack, always a hack. The worst justice on the court, bar none. A great ruling on the actual meaning of the statute, but there are unresolved issues here. Unresolved issues of statutory interpretation, unresolved issues of other laws, right? The statutory interpretation issues that I mentioned are just with respect to 12406. Like, what does inability mean in that context? Unresolved issues of constitutional authority for the president, inherent authority to protect federal functions, and unresolved power questions. What can the court rule on? When can they rule on it? And how much deference do they have to give to the president? What's coming up next almost certainly is going to be an escalation from the administration. This is something they're not going to take lying down. And they're already in danger of a legitimacy or credibility problem with respect to their power. And so keep an eye on that. And if there's any rumblings of the Insurrection Act, because the Insurrection Act would, as a legal matter, simplify their arguments. It's a step that until now they've been unwilling to take because it is seen as more serious. But the Insurrection Act would be a way to try to get around posse comitatus and to try to get around some of these barriers to invoking the National Guard. So keep an eye on that. Folks, I'm going to go do my last minute shopping. Stay cool. I love you all. I love the haters. I love all you guys. And I appreciate the support. All the subs, all that stuff. It was great. But I'll be back maybe tonight, maybe tomorrow. Not on Christmas, but certainly soon. Stay cool. I love you guys.